John emerges very badly. One might describe him as a nightmare figure from Amnesty International's point of view. Early 30s when he came to the throne, late 40s at the time of Magna Carta. He could, according to the chroniclers, take counsel amiably when he chose. He could be charming and courteous, indeed informally friendly in a rather coarse fashion, slightly reminiscent of the last German Kaiser. He was fine towards his subordinates, who did his bidding, to whom he could dispense patronage. He wasn't an idle ruler. His charters show a rather unpleasant hands-on approach. Unpleasant miscreants are to be hanged from the nearest oak. Jews to be protected, since even if we give our peace to a dog, it ought to be inviolably observed. But I'm afraid the evidence of his untrustworthiness, paranoia, violence, and gratuitous cruelty are overwhelming. The contemporary chronicler, known as the Anonymous of Béthune, from his own service with an Anglo-Flemish lord in John's service, said of him, "He was a very bad man, more cruel than all others. He lusted after beautiful women, and because of this he shamed the high men of the land, for which reason he was greatly hated. Whenever he told lies rather than the truth. He set his barons against one another whenever he could. He was very happy when he saw hate between them. He hated and was jealous of all honourable men. It greatly displeased him when he saw anyone acting well. He was brimful of evil qualities." Today we remember principally the murder of his nephew Arthur in Rouen Castle, ruthless removal of a close and young dynastic rival. But contemporaries were more appalled by many other similar acts. It was he who concluded his feud with the de Brieux family over land rights in Ireland by starving to death Matilda de Brieux, one of the most celebrated ladies of the age, and her son with her in Corfe Castle in 1210. He treated their lives as forfeit, as she couldn't pay off the fines he had imposed on her husband. Other examples of extreme cruelty. He also liked causing gratuitous hurt, informing his most consistently loyal supporter, William Marshal, Earl of Pembroke, that his steward, John of Early, had been killed in a battle as a joke, when it was in fact untrue. John was also unlucky. His inheritance of an Angevin proto-empire, stretching from the Scottish border to Spain, threatened by the rise of a powerful and centralising French monarchy. He proved unable to defend his possessions. He lost Normandy, Maine, and Touraine, and the concomitant revenue. It was those attempts to recover his continental possessions, his exactions by taxation and fines on his own subjects, to finance it, the arbitrariness of his actions, and the fear and uncertainty they engendered, which precipitated the crisis and civil war that led to Runnymede. Now, much is made today, I think, of the fact that very little of the Charter survives in our law. Indeed, of its 63 clauses, only 4 are still in force. Part 1, Clause 1, the liberties of the Church, Clause 13 on the liberties of the City of London, and Clauses 39 and 40, which are often cited as the defining statements on the rule of law and the limits of arbitrary state power. These two you may have heard said often, but they're worth repeating. No free man shall be seized or imprisoned, or stripped of his rights or possessions, or outlawed, or exiled, or deprived of his standing in any other way, nor will we proceed against him or send others to do so, except by the lawful judgment of his equals, or by the law of the land. And to no one will we sell, to no one deny or delay right or justice. But we shouldn't ignore the other clauses just because they haven't survived in their original form. They actually sought to address King John's unscrupulous behaviour, and above all to place limits on his exercise of power. So Clause 9 states that neither we nor our officials will seize any land or rent payment of a debt, so long as the debtor has movable goods sufficient to discharge the debt. Clause 20. A free man is not to be amerced, that's fined, for a small offence, and only in accordance with the degree of the offence, and for a great offence he's to be amerced according to the magnitude of the offence. saving his livelihood, and a merchant in the same way, saving his merchandise. And a villein is to be immersed in the same way, saving his wainage if they fall into our mercy. And none of the aforesaid immersements are to be imposed save by the oath of upright men of the neighbourhood. Tellingly, Clause 24 established that a sheriff or constable couldn't sit as a judge. The first open acknowledgement I think I've ever seen that you can't be both a member of the judiciary and the executive at the same time. And, very importantly, Clause 12 established that taxation could be only levied with the general consent of the kingdom. And Clause 14 tells us what that is. We will cause the archbishops, bishops, abbots, earls, and greater barons to be summoned individually by letter. In a recently published book on the Charter, the historian David Carpenter has analysed meticulously the likely foundations from which the Charter sprang. It was, of course, the fruit of a power struggle between King John and his nobles, men who were not themselves free of oppressing others when they had the chance. But the charter they extracted at Runnymede wasn't just a set of treaty terms. To justify their actions, they went back into concepts of justice that they saw as inherent to the realm and land of England of which they were a part, and which 150 years after the Norman conquest they clearly saw as a polity, not just a place where they happened to have estates and make money. At the end of the Charter, it's the commune of all the land that is to assist the 25 barons of the security clause in making John keep his promises. Those clauses speak of the law of the land, the law of the kingdom, the law of England. It wasn't laid down by legislation. It was part customary, partly the legal rules that already existed in the courts that his father had regularised before John's reign. But its purpose was to offer men justice, although this was undoubtedly according to their status and made a distinction between men who were free and unfree. But it really did set standards of kingship and governance that were supposed to be met. It drew on ideas of good and bad kingship that derived from the Bible, the coronation oath introduced in England in the 9th century, required the maintenance of peace and justice, and which by the 11th century was held to be the laws and customs of the realm. There's a lot of theological and canon law input which probably came from Stephen Langton, the Archbishop of Canterbury, key figure in creating the Charter. He'd written a commentary on Deuteronomy where, tellingly, he had criticised modern kings who collect treasure not in order that they may sustain necessity, but to satiate their cupidity. The Charter came as part of a cycle of civil war and violence, interspersed with earlier attempts at extracting concessions from the king. It didn't last long. Within a few weeks, John had it annulled, then abolished by Pope Innocent III, who John had acknowledged as his feudal overlord in order to get his backing. The rebel barons were excommunicated, a very unpleasant thing to happen to you in the Middle Ages if you believed in hell. King John showed no intention of observing it. The country plunged back into civil war. By the time he died in 1216, England was part occupied by the French, whose crown prince had come over to support the rebels and seized the crown at their invitation. The Charter was a failure. But quite astonishingly, the ideas in it, those concepts of justice and limited sovereignty, survived and were revived. Its first saviour was William Marshal, Earl of Pembroke, a great lord, the long-suffering and loyal advisor of the king and of his father Henry II and brother Richard I. And quite frankly, a national hero who ought to be remembered up there with Wellington and Churchill. His reputation for integrity was such that he was trusted by both sides. When John died, his young son Henry, William Marshal was elected regent by the other members of the council. Aged over 70, he proceeded to defeat and then through magnanimity conciliate the rebels and drove the French out of England, which is always quite a good way of getting public approval. He twice had the charter reissued in 1216 and 1217 as a promise of his intent that royal tyranny would be curbed. He died in 1219. You can go to the Temple Church in London and look at his effigy. When he died, the Archbishop of Canterbury described him as, at his funeral, as the greatest knight who ever lived. And that description really does stand the test of time. As a result of those reissues, also the issue of the Forest Charter in 1216 that covered royal rights in royal forests, and further reissues of Magna Carta in 1225 so that Henry III could get taxation, the Charter started to become embedded in our national consciousness. By 1226, we have records of knights in Lincolnshire criticising the High Sheriff for the way he was administering justice, behaving contrary to their liberty, which they ought to hold by the charter of the Lord King. Some great lords even felt constrained to issue charters of their own, regulating their relations with their own under-tenants, as Clause 6 expressly provided that the liberties under the charter had to be provided by them to their tenants as well. So Clause 60. 1297, the charter was turned into a statute, following yet another crisis over taxation. There's rather a long history of financial crises in England in the Middle Ages, which we seem to emulate today. In 1300, we have Essex peasants invoking it to complain of their lord bailiff's behaviour in the manorial court. At the same time, studies have shown just how effective the charter actually was in its principal aim. In 1207, King John's income, half his income, which was 22,000 of 44,000 pounds, came from the payment of fines. They were fines to avoid the king's rancour or recover land or get his benevolence. So they were blackmail payments. By 1242, the income from that type of fine was reduced to £4,000 per annum. So because they were short of money, kings such as Henry III had to summon councils, or as they were called by the 1230s, parliaments, to approve general taxation. As his financial needs grew of the king, so did resistance, with the usual demands from barons to choose the ministers, control the expenditure of money. And this year, of course, we also celebrate the 750th anniversary of a council summoned by Simon de Montfort after he'd seized control of king and government following another civil war. In order to validate his actions, he then issued orders for the election of 4 knights for each county to be elected to attend Parliament to discuss the business of the realm. By the end of the 13th century, this practice was institutionalised, and we get the Commons of England emerging as a distinct body with the right to grant taxes and the power to demand the redress of grievances in return. Writing in about 1180, an unknown Angevin official stated in a handbook called the Dialogue of the Exchequer, the Dialogus de Scaccario, an administrative manual that I hope George Osborne never succeeds in laying his hands on, that, and I quote, "The wealth of kings is not invariably theirs by due process of law, but proceeds sometimes from the laws of their countries, sometimes from the secret devices of their own hearts, and sometimes even from their mere arbitrary will. Their subjects have no right to question or condemn their actions." 100 years later, as a result of the process started by Magna Carta, that statement simply no longer reflected the new reality. As I mentioned at the start of this talk, references to Magna Carta rather diminished in the later Middle Ages, but it hadn't disappeared. An undertaking to abide the terms of the 1297 reissue was made by every king up to Henry V, and the lack of it thereafter is probably that it was now considered settled law. It didn't require repetition. 6 statutes in the 14th century extended it, and rather important statutes too, because for the first time its protections applied to all people irrespective of status, free or unfree. In the mid-15th century, at the time of the War of the Roses, a remarkable man, Chief Justice Fortescue, wrote a treatise, De Laudibus Legem Angliae, in praise of the laws of England, for the benefit of the son of King Henry VI. He doesn't make any direct reference to Magna Carta, but its principles are evident in it. Principles of which I think Amnesty would very much approve. He said this, and bear in mind we're talking of 1455. The King of England cannot alter nor change the laws of his realm at pleasure. For why? He governeth his people by power not only royal, but also politic. If his power over them were royal only, then he might change the laws, such is the dominion that the civil law purports when they say, the prince his pleasure hath the force of law. But from this much differeth the power of a king, whose government over his people is politic, for he can neither change laws without the consent of his subjects, nor yet charge them with strange impositions against their wills. Wherefore his people do freely enjoy and occupy their own goods, being ruled by such laws as they themselves desire, the power royal restrained by the power politic. Fortescue also stated that the statute required the consent of the whole realm, deprecated the use of torture, lauded the system of trial by jury and its uniqueness to England, telling the prince that his personal view was that he would rather 20 evildoers do escape death through pity than one man to be unjustly condemned. And his work, along with Magna Carta itself, were first printed in the 16th century. In the oath of office, which I took when I became Attorney General in 2010, and which is of Tudor origin and unchanged, I noted with amusement and pleasure that I was required to say, I will duly and truly minister the Queen's matters, sue the Queen's process after the course of the law and after my cunning. Now, cunning is not the Blackadder sense. In the 16th century, cunning was just your wisdom. But I then had to go on and say, I will duly and in convenient time speed such matters as any person shall have to do in law against the Queen, as I may lawfully do, without long delay, tracting or tarrying the party of his lawful process, in that to me belongeth, and I'll be attendant to the Queen's matters when I shall be called thereto. So in serving as the Queen's lawyer and representing her legal interests, even by the 16th century, the attorney had to promise, as required by Clause 40 of Magna Carta, not to abuse that position to delay justice for anyone else, even somebody seeking justice against the Crown itself. It was in the 17th century, however, that the use of the Charter in debate revived. James I came from Scotland and appears to have entirely misunderstood what the terms of the Charter actually were. When at Newark on his way south for his coronation, he ordered the summary execution of a cutpurse without trial or due process of law, to the consternation of his English entourage. It was something he'd got up to quite often in Scotland, particularly in the area where my family come from, where they were all bandits. It was called Jeddah law. He told Parliament in 1610 that the state of monarchy is the supremest thing upon earth. Kings exercise a manner or resemblance of divine power. So he believed himself free of constitutional restrictions. Perhaps not surprisingly, it brought him, then his son, Charles I, into collision with Parliament and his subjects, particularly these subjects who were lawyers. Opponents of the king, John Selden, who wrote a commentary on Fortescue, Sir Edward Coke, successively Solicitor General, Attorney General, and Lord Chief Justice, looked to Magna Carta to justify their belief in the dominance of parliamentary power and the common law over the power of the monarch. 1616, as Chief Justice, Coke defied James I when the king insisted that proceedings against the Crown challenging his right to grant a benefice should be stayed, that's stopped, halted. He said, the stay required by your majesty was a delay of justice, and therefore contrary to law and the judge's oath. He was then summarily dismissed. But Coke went on to be an MP, pushed through Parliament the Petition of Right in 1628, which was triggered by the imposition by Charles I of a non-parliamentary tax. The petition proclaimed its illegality, invoked the Charter in condemning arbitrary imprisonment for non-payment. His writings started to articulate the idea of what was called an ancient constitution. They started to think that there had been a common law of the Saxons, reinforced by Magna Carta, and now being subverted by the Stuart kings. It was a political crisis, ended by a messy and failed compromise. Charles next tried to raise revenue through ship money without using Parliament at all, on the grounds it was a prerogative right of the Crown to demand it to defend the country. Resisted by John Hampden. Hampden invoked Magna Carta, but lost in court. It certainly stored up trouble for Charles I. When he finally was forced to recall Parliament in 1640 to raise money to fight the Scots, it refused to vote any grant of supply, that's money, till Magna Carta and the petition were confirmed. Civil war followed. By its end, the king had been defeated and executed for the crime of levying war on his parliament and his own people. As for the parliamentarians, it's interesting to note that they then fell out among themselves and started repeating exactly the same arguments between them. There's something slightly ironic of, at the one extreme, the leveller and revolutionary John Lilburne claiming from Magna Carta the indubitable birthright and inheritance of a freeborn Englishman, and stating that any legislation passed contrary to it is null and void, an extreme assertion of the existence of some unalterable constitutional document. And Oliver Cromwell, his earlier ally, but now Lord Protector, dismissing an objection to a custom duty imposed by the Protectorate in 1656, with the words, "Your Magna Carta cannot control actions for the safety of the Commonwealth." I must apologise for so selective a canter through this rich period of the early and mid-17th century. I don't pretend at trying to do a narrative. I'd have to take all evening to do that. But I've done it because I hope it's illustrated how the Charter returned to the forefront of constitutional discourse in this period. In one sense, it was myth, as its use and interpretation bore little or no relationship to the issues or realities of 1215. But the myth was of the greatest potency. It was capable of being invoked on all sides in an argument. When James II overrode the Test Act with his Declaration of Indulgence in 1687, he was hailed by its supporters as the Magna Charta for Liberty and Conscience. The objectors pointed out it was on the contrary a flagrant violation of an extant statute by an exercise of the royal prerogative, and therefore breached the terms of the Charter. But in 1689, Parliament finally established its primacy in the Bill of Rights, after the overthrow of James II. And again, the Charter was referred to as justification. James was criticised for having sought to extirpate the Protestant religion and the laws and liberties of this kingdom. And the clauses of the Bill of Rights then went on to establish the powers and privileges of Parliament which it enjoys to this day, and to assert the primacy of the law and to protect the individual from cruel and unusual punishments. Subsequent statutes gave Parliament control over the armed forces, ensured regular elections to Parliament, gave judges security of tenure to ensure their independence. In the words of Igor Judge, our past Lord Chief Justice, who's written an excellent book on this with Anthony Arledge, which I strongly recommend to you, the ideas for which Magna Carta was the inspiration had triumphed. And since then, the Charter's continued to be invoked on many occasions in connection with political and legal rights. The Reform Act of 1832 was associated with its principles. The Chartist movement that demanded universal male suffrage, equal constituencies, paid MPs, I'm not sure people still want that nowadays, and annual parliaments in the 1840s deliberately took its name from it. The suffragettes used the barons' demands at Runnymede as a precedent for their own, and scenes of Runnymede appear in their leaflets. It's also right to say they took direct action, just like the barons. The principles in the Charter and the Bill of Rights have also, as you'll be aware, been readily exportable to Britain's colonies. It was very early established that all the protections of the common law applied, even if the individual state could also enact its own legislation. The Maryland Assembly in 1638 incorporated Magna Carta as part of its law. When the United States achieved its independence, its Bill of Rights consciously reflected the rights in the Charter. The Fifth Amendment to the Bill of Rights of 1791 says, "Nor shall any person be deprived of life, liberty, or property without due process of law." Clearly echoes Clause 29. Indeed, in 2004, there was a Guantanamo case in the Supreme Court of the United States, Rasool and Bush. It stated that executive imprisonment has been considered oppressive and lawless since King John at Runnymede pledged that no free man should be imprisoned, dispossessed, outlawed, or exiled, save by the judgment of his peers or the law of the land. As I saw at the recent Global Law Summit in London, which I helped organise a couple of weeks ago, it's a shared inheritance in every common law country, and furthermore respected and understood to be of global importance in many states which don't have a civil law, which don't have a common law system, but a civil law one instead. Now today, it's right to say that the Charter isn't the place in which free-born Englishmen will necessarily first turn for the protection of their rights. Claimants usually go to court to invoke their rights under the European Convention on Human Rights, signed up to by 47 European states, and which the Human Rights Act has incorporated into our domestic law. The 10 key rights set out in the Convention cover, I hope you'll forgive me if you already know them, but they're worth repeating: the right to life, to protection from torture, prohibition of slavery and forced labour, the right to liberty and security, the right to a fair trial, no punishment without law, the right to respect for your private and family life, freedom of thought, conscience and religion, freedom of expression, and freedom of assembly and association. And there are a few others as well. This list of rights, although usually met with approval as a concept, has not, however, exactly made the Convention universally popular. It's routinely denounced in some sections of the press and by some politicians as a foreign import, despite the key role played by British lawyers in actually drafting it in 1949-50. Indeed, I, on a number of occasions, receive letters from angry constituents, and they tell me that it's quite unnecessary for us to be subject to the European Convention on Human Rights. And they usually go on to say, as this country, our liberties are quite sufficiently protected by Magna Carta, Habeas Corpus, the Bill of Rights of 1689, and the common law. They also, it's argued, that in the way it's interpreted by the courts, it interferes with parliamentary sovereignty, confers excessive rights on the undeserving, prevents the state from protecting the wider community from the threat from dangerous and undesirable individuals. But the reasons why the United Kingdom helped draft and signed up to the Convention are interestingly entirely in line with the reasoning of those who created or those who subsequently revived Magna Carta. In the aftermath of the Second World War, there was the greatest anxiety that the tyranny and abuse of rights and freedom that had characterized the period should be prevented from recurring in future. It was Eleanor Roosevelt who, in promoting the United Nations Universal Declaration of Human Rights, described it as a Magna Carta for the 20th century. It was in order to give the aspirations of the United Nations Charter some possibility of implementation in practice. And of course we know that many countries subscribe to the UN Declaration, but unfortunately not all that many observe it. So it was in order to get round that the member states of the Council of Europe created the European Convention and agreed between themselves by treaty that its terms could be interpreted by an international tribunal, known as the European Court of Human Rights, in Strasbourg, and bound themselves to observe its rulings in any particular case which related to their own country. It was the same impulse which allowed them later to agree to the right of individual petition, which first gave citizens the possibility of access to the Strasbourg Court that had hitherto only been available to member states of the Council itself. As we've seen, the interesting thing with Magna Carta is that the barons were prepared to accept limits on their own power in return for creating a more predictable set of rules governing relations with the king. In the European Convention on Human Rights, as in most treaties, the state parties accept potential checks on their own actions in return for the security that other parties will be bound in the same manner. As has often been pointed out, those 10 key rights I listed, with the exception, I suppose, of Article 8 on privacy, are in reality a classic exposition of the liberties which successive generations of Britons have taken to be their birthright. But how well they were in practice maintained through the centuries, how accessible was redress when they were violated, is, I think, far more questionable. It's not so long ago that we were dealing on a routine basis with confessions extorted in police stations under psychological or indeed physical pressure. Plenty of examples, unfortunately, in our history of the violation of the rights, even if they were there. But I, of course, entirely accept that the national narrative since Magna Carta has been so powerful that it's usually acted as an almost mythic restraint on successive British governments whenever they've tried to curb freedoms when tempted to do so. Recent examples include 90 and 42-day pre-charge detention under the last government, which was miraculously defeated in Parliament. It's doubtless the case that most Britons considered in 1950 that our common law tradition of liberties, upheld by a democratic parliament, offered a superior level of protection for freedom than any continental model. So in signing up to the convention, we were doing something new. We were intent, I think, at the risk of innovation, through the creation of rights that we ourselves enjoyed as liberties, not so much on protecting ourselves, but on setting a standard of behaviour for states towards their citizens that could be universally applied. The decision wasn't uncontroversial. At the time, contemporary Foreign Office advice expressed fears that the convention would be subverted. It said, and I quote, "To allow governments to become the object of such potentially vague charges by individuals is to invite communists, crooks and cranks of every type to bring actions." But as we know today, the European Convention on Human Rights has created its own dynamic. By converting liberties to rights, it's facilitated their ownership, the ability by individuals to assert them rather than just being mere invocations of abstract principles against administrative or policy decisions. The anger of the tabloid press at undeserving claims, those crooks and cranks, is, I'm afraid, the inevitable corollary that claims by the deserving can now much more readily be made. And deservingness cannot be determined a priori before you've had a hearing. Some argue, this has taken the interpretation of the convention by the Strasbourg court and indeed by our own courts, to places unintended by the original signatories. But I have to say, it seems to me it was quite clear from the outset that it was understood that this was likely to happen. It's been the intention and policy of successive United Kingdom governments in the modern era, over the last 2 centuries when I say the modern era, to seek to make the world a less dangerous, more predictable and better place by encouraging the creation of international agreements governing the behaviour of states. I once asked the Foreign Office how many treaties the United Kingdom had signed. They were unwilling to go back before 1834, but they told me that since then they had records of 13,200 treaties and agreements that the United Kingdom had signed and ratified. Of course, they range in importance from the UN Charter, the European Convention of Human Rights, International Convention on the Prohibition of Torture, the creation of the International Criminal Court, to local treaties over fishing rights. Interestingly, over 700 contain references to the possibility of binding dispute settlement in the event of disagreements over interpretation by a third-party court or arbitration, which of course is exactly what the European Convention on Human Rights provides. For that matter, exactly actually what Magna Carta provided when it set up a council of 25 to keep and cause to be observed the peace and liberties granted under it. And I would add that it's so important as this treaty making become that the ministerial code issued by every incoming Prime Minister, including the present one, specifically states it's the duty of United Kingdom ministers and civil servants to respect our international obligations. The late Lord Bingham, who was Lord Chief Justice, described this duty as one of the key underpinnings of the rule of law, and we ought to be proud that it's at the forefront of the way government is conducted in this country. Indeed, for 4 years when I was Attorney General, most of my time was spent trying to make sure that exactly that underpinning took place. Now, that's not to say that everything concerning the Human Rights Act and the European Convention on Human Rights is perfect. Valid criticisms have been made by our own judiciary that the Strasbourg Court has failed to respect national differences of interpretation of the Convention, which should be allowed under the principle which is called the margin of appreciation. You have a right to have a margin where you can do what you want. It's also failed to appreciate sufficiently the practical limits of its authority if it gives judgments which contradict settled democratic will in areas where the margin of appreciation might be reasonably considered to apply. And the obvious example of this is the still running dispute over whether convicted prisoners should or should not have the right to vote. In part, I think the Strasbourg Court has been the victim of its own success. It's been transformed from an international tribunal, which was supposed to deal with a tiny number of cases, into a final court of appeal for nearly 700 million people. In service to what's been an understandable desire to protect human rights in countries with frankly challenging records in Eastern Europe and elsewhere, it sometimes micromanaged the convention too much, sought to impose a uniformity of practice that is undesirable in the interpretation of an international treaty that specifically gives to national parliaments and courts the primary obligation to uphold its terms. But there are good signs that following a review of the Convention and the working of the Strasbourg Court, which culminated in the Brighton Declaration of 2012, led by my friend and colleague Ken Clarke, change is occurring. The Court's backlog of cases for processing is reducing from a terrible level of about 150,000 cases at one time. Recent judgments from Strasbourg, such as that upholding our national ban on political advertising, show a growing willingness and sensitivity to respect the reasoned decisions of our own national courts. But these problems are really outweighed by the good that the Convention is doing. A moment's examination of its caseload shows the extent of its reach. I'll just take a couple of examples for you. From Azerbaijan, where the court ruled in 2013 against the government there for imprisoning after a totally unfair trial an opposition leader, Mr. Mammadov, for inciting a riot after he'd published a blog post contradicting the government's version of what had occurred at a demonstration. I might add that the judgment of the court against Mr. Mammadov, they simply took the prosecutor's opening submissions and published them as the court's findings. Romania, where the court found a violation of the right to life, where a severely handicapped young man was allowed to die through gross neglect in a psychiatric hospital. In all these cases, the Strasbourg court is helping to improve human rights. Despite the fact that some of the judgments may be implemented only slowly, the evidence suggests that political pressure from the Council of Ministers, a modern version of the Council of the 25 Barons, eventually leads to success in this regard. The authority of public judgments is helpful in changing the behaviour of authorities in the states concerned. For all its challenges, the Convention has proved and is proving to be an effective tool. Not perfect, but really effective. Perhaps the single and most cost-effective one currently available for promoting human rights on our planet. Of course, none of that means that Magna Carta is redundant. As its principles can be clearly discerned in the text of the Convention, so its citing can add weight to arguments when important freedoms are called into question. Last year, you'll remember, there was understandable anxiety on the threat posed by alleged terrorists returning from Syria and Iraq. It led to suggestions that they should be excluded from their homeland here, even if they were not convicted of anything and were British-born nationals. Fortunately, good sense prevailed, as rendering a person stateless by excluding them from their own country of birth is a breach of our international obligations under both the European Convention on Human Rights and, for that matter, the International Convention on Statelessness. But I have to say, I found it very helpful when discussing the matter in Parliament to gently point out to my colleagues that you can go back to Magna Carta, and there you have in clause 42, "It is to be allowable for anyone henceforth to depart from our kingdom and return safely and securely by land and by water, saving our faith, save in time of war for some brief time, for the common utility of the kingdom, except those imprisoned and outlawed according to the law of the kingdom." Yet again, one finds that the problem we experience today has already had to be tackled. The journalist and author Paul Johnson wrote a history of the English-speaking people. And in it, he said something which has always struck a big chord with me. The extraordinary attachment of the English to their system of law, if indeed it can be called a system, the positive affection it inspires, the awe-inspiring confidence, often unwarranted, which they repose in its ability to do justice, the tenacity, indeed the ferocity with which they refuse to modify it with foreign importations, is one of the most important national characteristics. And he went on. In a sense, the law is the only true English religion, the only body of doctrine in which the mass of ordinary Englishmen have consistently and passionately believed. It's impossible to turn to any period of English history where written records have survived without finding a huge and dogged conviction in the adequacy of the law, if only, and this is the vital qualification, it is administered according to tradition and custom. So, ladies and gentlemen, I think we have reason to be very grateful to those who drew on their vision of what the law of the land was in 1215 to frame Magna Carta. Not only did they initiate a process which has created a discernible line of beneficial rights and liberties carried down in various forms to the present day, and I have to say growing like a rolling snowball as it has progressed, but they offer us a mirror in which we can see today that the challenges we face in promoting the rule of law are not new and will probably continue, but will still need to be met. Precedent, much used in our courts, suffuses our national life. It makes beneficial change when it comes much easier to manage and to achieve. In this 800th year of Magna Carta, we have much for which to be thankful.